All right. Why don't we go ahead and get started? And we are so excited that you all have joined us for this webinar this afternoon. IP and standards strengthening U.S. manufacturing and supply chains. My name is Lauren Gatus. Like I said, I know some of you and some of you I don't know. So for those of you I don't know, I'm excited to moderate today's conversation on behalf of Save Our Standards. Save Our Standards, we are a coalition of innovators, small businesses, manufacturers, associations, academics, consumer groups, industry leaders, all in support of the FRAND, or the Fair, Reasonable, and Non-Discriminatory Licensing Commitment. For those of you who are new to this issue, you probably are like, what is she talking about? Well, we are happy to sort of give you all a primer on this and why it is so important to manufacturing and supply chains, because I know for me personally, sometimes you hear about some wonky IP issue and you don't necessarily think that it's going to have an impact on your day-to-day life or the companies that you interact with, but it certainly does. And so for those of you who are not familiar, technical standards are commonly agreed upon specifications that allow products and components made by different companies to work together. So you are probably using many of them as we speak. These standards include Wi-Fi, 5G, other connectivity technologies, and they support interoperability across many different industries, vehicles, industrial equipment, medical devices, consumer electronics, connected infrastructure. For the some of these standards have patented technologies that are contributed to them, and those patents are known as standards essential patents, or SEPs. And when patent holders contribute those technologies to a standard, they make a commitment to license their SEP on FRAND's terms. So that commitment is intended to ensure that patent holders receive fair compensation, while manufacturers and other standards users can predictably license the technology needed to build interoperable products. But as those of us on this call have seen, sometimes SEP holders can abuse the fact that they own SEPs. And so today we want to talk about sort of the practical side of this and how SEP abuse impacts manufacturers, product companies, suppliers, retailers, small businesses. And we'll discuss how licensing uncertainty affects investment and supply chain planning. I'm going to stop talking, or I'll introduce our panelists, and then I will kick it over to the experts who know a lot more than I do. We are lucky to be joined by Kent Baker, founder and principal of Convergent IP Advisory, who brings more than 3 decades of experience across engineering, standards development, intellectual property strategy, licensing, and tech policy. Joe Mattal, who's currently the principal at Clear IP and previously served as the acting director of the USPTO, as well as acting solicitor for the agency's legal department. Rebecca Porath, an independent IP and standards policy expert who previously served as global IP policy manager at Intel and earlier as standards coordinator for Philips Consumer Electronics Division. Rebecca brings experience in both standards development and global intellectual property policy. And finally, Charles Dewan, who is an assistant professor at American University Washington College of Law. His research focuses on how intellectual property and technology law interact with public policy and the public interest. So we are super thrilled to have our panelists here. Before I kick off the conversation, I'll just note we will be taking questions from the audience, so please feel free to enter your questions into the chat or into the Q&A box. And with that, like I said, I'm going to stop talking. So I'm going to start with Kent. Let's begin with the basics. Technical standards, standard essential patents can sound like highly specialized issues, but they affect products across nearly every part of the economy. How do those technical standards support manufacturing, and where do SEPs and FRAND licensing fit into that system?
Yeah, that's a good question, Lauren, because everyone should be very comfortable with standards. You're using them and you don't. As Charles and I discussed at the beginning of this, or just prior to this webinar, even your language you're speaking is standardized. Folks came together and figured out how to best communicate. But if you look at formal technical standards governing manufacturing, And then interoperability, which actually evolved later in the standardization process, it goes back thousands of years. 3,000 years ago, you knew it as weights and measures. We all know that when every time we step on the scale and see how much weight we put on from Christmas. The Roman Empire brought you standardized road widths, pipe gauges, military equipment, and like that. You have the Industrial Revolution, standards were still there. And for anyone who's ever tried to put a nut on a bolt, well, that was standardization circa 1841, when you had a standard screw thread chart put out that you could build nuts to so that you could actually assemble things. Now, that's very rudimentary times. As you can see, standards tended to go to single product applications. You made the bolt, you made the nut, they fit, everyone, could move on with it. Now, modern consensus standards, where you get companies together, those are the ones we're talking about today, which are ANSI, IEC, ISO, IEEE. They all had predecessors that all go back to this basic core concept of standardization. And that concept is basically that an independent supply chain and manufacturer would voluntarily build interoperable products to a common technical standard. All right. And as you mentioned, Lauren, we see that with cellular, Wi-Fi, video codecs, wireless charging. What has been lacking during this development process since the mid-1990s has been governance that has lagged significantly in trying to provide a predictable roadmap for the implementation of those standards. Appreciate that prior to 1985, participation in standards development was primarily motivated by product interoperability and market growth. You did it because you were trying to actually help develop a market into which your product would go, whether it's component, whether it's an end product. But patent licensing generally didn't exist. It was ancillary to standardization because a lot of the companies you had working between each other took a defensive posture and said, I'm big enough and you're big enough, we'll just go ahead cross-license if we even need a license. Or we'll just say, we'll use each other's patents and let's focus on developing the market and building product to drive our profitability. Now, between 85 and 1995, that's when digital communications came in. That's about the time period I came into standardization. And the expectation that successful technical contributions could generate a business advantage and substantial FRAND licensing revenue became widely accepted. I know I was at Qualcomm at the time and helped with that licensing program. And it was somewhat revolutionary and controversial at the time, but wasn't a big enough problem for people to address. However, it shouldn't be surprising that as things have evolved and these standards have become more complex in their interoperability with multiple technologies converging onto a single platform that the consumer sees, a good example, your cell phone, it's becoming more increasingly conflict-filled within the standards ecosystem. Appreciate standards are there to standardize the product, the component, and the build. It really doesn't deal and shouldn't deal with the business aspects of the use. Well, when you have the ability to practice a particular business model without any type of guardrails around it or governance that says this is how you will set up a predictable way of doing FRAND SEP licensing, which it has evolved into, you can see why there's some problem children out there that are abusing the patent process. I personally have experienced, after representing a company that needed to use a patent portfolio of a large patent holder, and that patent holder changed their business model about 4 or 5 years ago. And they said, we're not going to license at the component level anymore, and we think that this is fine. Then they went ahead and jacked the royalty rate up by a factor of 7 or 8 and said, this will be your new license. There was absolutely no discussion about whether it was FRAND or anything else. And I can tell you 90% of the companies in IoT, smaller companies, are not in a position or at a sophistication level to argue against that type of positioning or to fight it. So what you get is you get almost a default license, or the patent holder screams holdout, that you're not taking the license when you should, and that's not the issue at all. But going back to that distinction between what standards used to be prior to 1985 and what they currently are, is historically significant because it explains the modern debate over FRAND, holdout, aggregate royalties, the role of SEP licensing that just didn't exist before. They only emerged after standards themselves became repositories of high value patented innovations that business advantage could be derived from right, as opposed to just the proliferation of the standard for the public good and looking at also at the impact, on the public. So your question was, how is it affecting manufacturing and supply chains? Current regional government um, just is lacking in providing leadership and guidance for SEP licensing on FRAND terms. It's a bit of a mess, and it really doesn't strongly support modern manufacturing that's required to go ahead and proliferate that standardization.
Thank
So
that
that's
was
a
a
little history for you and why we're where we're at.
That was a great overview. And Kent, your voice is so valuable here too, especially since you've seen firsthand, like you were talking about, when this sort of falls off the rails and when patent holders abuse their position as a SEP holder. Rebecca, you have worked directly in both standards development and global IP policy. From the perspective of companies participating in the standards process, what is the bargain underlying the FRAND commitment, and why is confidence in that commitment so important to the long-term integrity of the standard system?
Um, Generally, companies voluntarily participate in developing a standard. That makes for the difference between technology mandates that may be issued by individual governments, but standards are generally developed and adopted voluntarily. And when companies voluntarily participate in developing a standard, they will want that standard to be successful. That is to say, they want the standard to be as widely adopted as possible. The most successful standards are actually adopted globally. Especially ICT companies, I have a lot of experience in ICT, will often need standards to be globally adopted. Otherwise, they will never achieve the economies of scale that enable them to bring innovations to market at affordable prices. That is why global standards are an important basis for the fast-paced innovation that we have been seeing in the ICT field over the past decades. The inclusion of patented technology in a standard presents potential challenges to wide adoption, simply because patents allow their owners to exclude others from using the technology, and thus from adopting the standard, and thereby they limit the adoption of the standard. Alternatively, SEP holders, again, SEP stands for Standard Essential Patents, could decide to only allow some companies to use the standard, or they could decide to exploit the fact that nobody can use the standard without a license to their patents and demand royalties that go far beyond the technical value of their innovation, of their inventions. And that is why, from the perspective of standards developers, standards development organizations seek voluntary commitments from the owners of such standard essential patents to not use their patents in those ways. That is, they seek commitments from those patent holders to offer license to anyone seeking to implement the standard on fair, reasonable, and non-discriminatory terms. In some cases, standard development organizations further specify this and seek commitments to offer licenses on royalty-free terms. And we have many very successful standards that have been successfully developed under such policies. In other cases, royalties may be sought from standards implementers, but are constrained to fair and reasonable amounts. And essentially, the FRAND commitment becomes a condition for the patented technology to be included in the standard. And it creates, if you like, a win-win bargain between implementers and SEP holders. SEP holders gain the potential opportunity to obtain royalty payments from every implementer of the standard, making for a very, very significant licensing market if the standard is successful. And implementers gain the opportunity to use the standard without having to fear excessive royalty demands that they cannot walk away from without adopting the standard. And in this way, the FRAND commitment is essential to the role of standards as enablers for innovation. And conversely, uncertainty about the reliability of FRAND commitments directly threatens that role.
Thanks, Rebecca. That win-win is that's such a good distillation of how this works. Joe, I want to turn to you. You sort of drawing on your experience at the USPTO and in private practice, how does uncertainty and inconsistency in SEP licensing affect product development, sourcing, and manufacturing decisions before a dispute might even reach a courtroom?
Well, you're starting to see a lot more industries impacted by this as basically as communications technologies spread. And suddenly, an industry that never had to deal with these issues before, now its products have connectivity. And sometimes, it's not even optional, like for automobiles, regulations require connectivity for safety reasons. And suddenly they're, dealing with these, SEPs issues for the first time. And, the patent enforcement system was developed, long before SEPs were a thing, and it wasn't, nothing has ever been designed or developed to accommodate, actually setting or determining what's a reasonable royalty. You basically have to litigate the patents piecemeal. There's no way to know what other patents are out there, et cetera. And, one of the industries that's kind of had to deal with the roughest end of this recently is manufacturers of TCUs, telematic control units, which are the baseband processors that enable connectivity in cars. And they found that they just, as Kent mentioned, the major SEPs holders won't even license to them because they're, deemed a component supplier. They'll only license the cars. And then you run into the general problem with SEPs that you can't even know who's out there. Sometimes, like for some standards, you'll get a pool, but sometimes you'll get more than one pool, and then there are still major portions of patents outside of the pool. And even if you license everyone, you can't know who's out there. And what you're starting to run into is, well, if people won't license you, then you just have to make stuff at risk, and then your customer gets sued later on. And this is the scenario that's played out in the auto industry over the last decade. Then your customer is sued in a place like Germany. They give you automatic injunctions, basically. That customer just pays whatever and comes back to you for an indemnity. In a lot of industries, still standard to do an indemnity, not in the chip industry, incidentally, but and then that indemnity demand ends up being like not only more than your entire profit on the component, but sometimes as much as the entire product itself. And we're reaching a point where it's going to be, if this continues or if these types of problems continue, you're obviously just not going to have mid-sized manufacturers making these components anymore. What we're evolving into is a system where only the largest vertically integrated enterprises are really in a position to even make these components, and everyone else is effectively out of the market. I mean, if you can't know, what your rates are, what you need to pay to use a technology until years later, and it can end up being something that makes the whole enterprise unprofitable, then people will just leave that business. And we see people leaving the TCU business. And recently, and I think it was in the field of digital television, these types of problems have gotten so severe that I think it was even LG announced that it's not going to be making screens that implement the latest digital television standard, and they cited the patents. There's just too much uncertainty over, they're just sick of getting sued on piecemeal patents and finding out, 10, 15 years later what their liability is, rather than being able to know upfront what does it cost to use the standard and what price do I need to bake into this product. That's the only time I've ever seen that where a standard is actually just not being implemented by anyone, because of these kinds of uncertainties in the liability. But again, it comes back to as that manufacturer, there's just no way to know. There's no kind of business planning accessible way to gauge what your liability is going to be. There's nothing to force all the patent owners to participate in a pool. Again, sometimes you get multiple pools and then a lot of people outside of the pool. And and the threat of injunctions in certain jurisdictions or in the ITC just adds a crazy level of risk to these things. So again, we're kind of on a path of, only the biggest players can even manufacture these products. And then we're also increasingly on a path of people going to foreign jurisdictions to get licenses. And there the pattern is, well, patent owners like to go to Europe, especially Germany, because then you get an injunction. Manufacturers, especially China-based manufacturers, prefer that the rates be set in China. And increasingly, these jurisdictions are willing to set global standards. They say this applies not just to our domestic patents, but to all patents worldwide. The UK started that in 2016 with the Unwired Planet decision. And, once one country starts it, it's hard to tell others like, oh, no, that's only the Brits. It's some legacy of colonialism. Like, no, 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 the Chinese government feels perfectly entitled to do this as well. As you can imagine, China sets very low rates. It's still, their interests are still in manufacturing rather than in the patents. The UK still does this. The UK seems about the fairest jurisdiction for this. In the US, you can't do this because there's a strong presumption against extraterritoriality in US law. And so far, there have been a few cases where people have gotten a SEPs license, but kind of a broader license. But so far, U.S. courts have been very resistant to doing this, and you're pretty much just stuck with, if there's not a pool, you basically have to do piecemeal litigation over individual patents, as they're asserted. And there's not a lot of transparency even over what's been licensed in the past, et cetera. So it's become a very treacherous environment, and in some manufacturing spaces and one that really just makes it impossible for any small or medium-sized entity, to even operate, with this level of unpredictability.
Thanks, Joe. That I really want to build on the problem of injunctions that you were talking about. So, Charles, from a patent law and public policy perspective, why is it important for courts to distinguish between protecting legitimate patent rights and allowing the threat of an injunction to create leverage beyond the value of the standard essential patent? And what are some of the broader consequences for manufacturers and consumers when that balance is lost?
Yeah, so that's a fantastic question. I think it really builds on a lot of the answers we've gotten so far. Basically, the combination of injunctive relief and a standard essential patent creates a situation in which it becomes really, really possible for a patent holder to extract excessive value from the patent, as Rebecca was mentioning, or as Kent was saying, to take advantage of the holdout value of patents. And that sort of excessive compensation then has downstream effects on the companies who are thinking of implementing standards, like Joe was saying, that companies might decide that they're not going to implement standards. And that has further downstream effects on whether or not standards get developed in the first place. Now, I teach this concept in my patent law class, and I've always found that it works best if I actually go through sort of what the problem with an injunction is by example. And by virtue of being a law professor, you've all been to law school, you know that I get to take advantage of this correct method. So, Lauren, would you be willing to help me out with a little example here?
All right, let's see.
Fine, you'll do great. So, Laura, I want you to imagine that you're a patent holder. You've got a patent on, say, Wi-Fi, standardized technology. This patent is important to Wi-Fi. It contributes, say, like $10 of value to the Wi-Fi standard. Okay. I'm a laptop manufacturer. I make laptops. Laptops, of course, use Wi-Fi because they want to be able to connect with standard Wi-Fi routers, access points, such. They also contain lots of other features. I make $1,000 off of profit off of my laptops because they contain all of these features. Now, if we were to have a legitimate negotiation, what do you think should be the royalty rate I pay you, Lauren?
So the value of the patent is
Your
$10.
patent is $10, yeah.
Um, $10?
I imagine $10, right? That sounds fair. You get your contribution, I get my contribution to technology, right? That would be a normal, reasonable, rational royalty rate. But now say you sue me, you get an injunction. I no longer can sell laptops. Now, is it going to make any sense for me to take Wi-Fi out of my laptop? Nobody's going to buy it, right? So, are you just going to ask me for $10 when we negotiate after the injunction now? Would you like 20?
I mean, if I can get 20,
Well, from my perspective, either I'm stuck with an injunction, I can't make any money, or I give you $20 on this $10 patent. I'm going to do it because at least I get something. You want to ask for 30?
Sure. Let's say 50. Let's go 100. Let's go
In
crazy.
fact, how much can you ask for?
Right.
You can ask the entire value of my profits, can't you? And I still have to say yes. Your $10 patent is now earning you $1,000, and I'm paying out my entire profits to you on that patent. That's what we call the holdup problem. The fact that even though you've got a patent on just a very minor part of this technology, you can demand huge amounts of profits, excessive amounts of compensation. Now say, Kent, you've got another patent on Wi-Fi. How much are you going to ask me for?
I'm going to start at 20 and go up.
Start at 20 up, so you're going to be generous. Once we start adding these numbers up, I'm paying more than my total profits out. Each of you are acting rationally. You're asking for what you should be asking for. And now it is unprofitable for me to be selling laptops because I have to pay out twice my profits and royalties to both of you. That's a problem that we call royalty stacking. And because of the fact that, as Joe mentioned, there are often thousands of patents on these standards, that problem gets multiplied over and over and over again. And so this is what happens when you have that intersection of injunctions plus standard essential patents. The implementers are then forced to potentially pay out huge amounts. What's my rational decision now? I'm not going to implement the standard because it's going to cost me too much. It's going to be too complicated, just like Joe was saying. You'll see companies start pulling out of the standards process and stop implementing standards. And what's that going to mean for consumers? It's going to mean you're going to end up with a bunch of incompatible devices, and nobody wants that. And so that's sort of the snowball effect that you get. And that's why you end up with pretty significant public policy consequences once you start allowing for that intersection of injunctions and standard essential patents.
Charles, I know a lot about standards, and as soon as you put me on the spot, I was like, oh, I hope I get this right.
You did great.
Thank you. Keeping me on my toes. But I want to build on that because in the United States, when it comes to injunctions, we rely on the Supreme Court's eBay framework, which requires courts to apply the ordinary equitable test before granting a patent injunction. So Kent, I want to ask you, why is that balanced eBay framework so important in SEP cases where a patent has voluntarily committed to offer licenses on FRAND terms?
Yeah, I'm going to build on what Charles and Joe and Rebecca have said also, because this is an area where things tend to overlap. Having a fair process by which the positions of both parties are evaluated to determine the fairness in FRAND or fairness in an agreement, that's a crucial starting point. A lot of the injunctive practices that are used in non-US courts that do not apply eBay, they take a very different approach. And whether or not the individual who's going to implement the patents has an opportunity to present their position on what would be FRAND and why what is being offered is not FRAND, that can fall by the wayside very quickly. Having done literally hundreds and hundreds of licenses, I can tell you if I can get an injunction, that is the first discussion that I have with a prospective or with a client, is how are we going to get max leverage in this licensing discussion to drive revenues? The debate about whether it's FRAND or SEP, that's almost a policy issue. Well, that is a policy issue at this point, because if it's too excessive, I know I'm going to be reprimanded by the court, or I may have something initiated, such as we saw over in Europe with the first foundational legislation I know of that tried to put some type of guidance into the SEP-FRAND debate. And of course, that started to flounder when intense lobbying over at Parliament in the EU started to create some issues. But the eBay decision, it allows that kind of consideration of both sides to determine, do you truly have hold up? Do you have hold out? And what are the broader considerations in trying to get a SEP decision going? Now, I don't think it's unusual that when automotive from telecommunications, the SEP-FRAND issue crept into automotive. I don't think it was to anyone's surprise that that was brought in Germany, and that the patent pool that had the greatest interest in driving members to it that was not being successful doing that had its members bring individual lawsuits in a jurisdiction where injunctions would issue. And you're in the problem that Joe talked about where, and Charles about, where you have to take that license regardless because you cannot stand the disruption to your business. I was asked as an expert about, well, wait a second, some cross-exam. Did that incremental increase in the intellectual property costs really cause this business to go out of business and to leave that area and to withdraw from manufacturing wireless modules. That was such a simplistic question. It reflected that the person asking it didn't understand how businesses actually work, how component manufacturers work, how financing works. And when you get such instability in the system that you cannot predict, because remember, competing in a global market against Chinese companies, Westernized companies, and like that, when you're looking at product positioning and pricing to sell that component into a larger end product, but you can't determine what your patent hit would be, nor can you go ahead and determine what the risk would be, your financing and ability to do business starts to dry up, and it has an impact throughout the supply chain. So there are a lot of symptoms that we're seeing now to a sick SEP-FRAND regime that are going to manifest themselves as we move forward.
I want to build on that a little bit, particularly that investment and that financing piece that you were talking about. Joe, can you talk a little bit about how this impacts investment into companies and supply chain planning? And if more injunctions or product bans were allowed in USF disputes, how that could impact the investment side of things?
Well, I guess one of the best examples I've heard recently is it's just the last couple of years that it's become more or less clear that you get automatic injunctions in Germany. It's something the courts themselves set up. No one passed a law, and I know that one of the major semiconductor manufacturers, when they had to dial back some of their plans and were deciding which projects not to go forward with, they canceled the ones in Germany. Because if you're spending tens of billions of dollars building a chip fab, the last thing you want is the risk that an individual patent owner can come in and get an injunction and shut you down. So it's about as stark an example I've heard of how that affects and drives investment. In the U.S., under eBay, you basically, no one's really tested the issue, but seems pretty clear that the FRAND commitment is inconsistent with getting an injunction to protect exclusivity. It's kind of the opposite. In the U.S. case, I mean, this is kind of controversial, but it shouldn't be. The FRAND commitment really arose out of antitrust standards and litigation. FRAND actually first arose in the U.S., and it pretty clearly comes from a case that was litigated in the 40s that involved glass makers, like makers of bottles and bottle making equipment, and this case called Hartford Empire that made it all the way up to the Supreme Court. And what had happened is that basically the six biggest makers of the bottles and equipment got together, cross-licensed each other's patents, and then agreed to freeze out everyone else. And I think they even carved up the country geographically as to who would have regions. And you get people who make the argument that antitrust can never apply to patents cases. And in this case, the Justice Department wasn't buying it, and this walked, talked, and squawked like an antitrust violation. And they won at the Supreme Court and got an order that, among other things, they had to license the patents to anyone else on FRAND terms. So that's actually the origin, of this term. And as the Supreme Court has recognized subsequently, in any standard-setting organization, you basically have horizontal competitors cooperating, agreeing how they're going to compete in the market, which is a situation, rife with opportunities for antitrust restrictions. You certainly don't want those horizontal competitors getting together and freezing others out from the market, for example. And the other aspect of it, and the reason that reinforces why FRAND is used by virtually every standard setting organization, is obviously the standard isn't that useful if someone can get an injunction and prevent others from, that kind of defeats the whole idea of a standard if one of the participants that can then freeze others out of using the standard. So in terms of the distorting effect of injunctions, in addition to Germany, you can increasingly, it seems like, get injunctions in Brazil. The courts there seem to order injunctions now, and Brazil is a big enough market, and people have enough invested in capital there and factories that you can't not do business in Brazil. So they have the leverage to issue injunctions and compel licenses at that point. But the best example, the kind of prototypical example of the distorting effect of injunctions is the NTP litigation from the aughts in the United States. This was the suits against BlackBerry by an NPE, and a jury initially assessed the NTP patents as worth, I think, about $20 million. And then in follow-on litigation, this was before eBay, and you got automatic injunctions. Once they basically got the injunction, the court agreed to issue the injunction, and then they settled, and that $20 million jury assessment resulted in a settlement of $600 million, because at that point you're not negotiating over what the patent's contribution to the value of the product. You're negotiating over how much damage that injunction would do to someone's business, and obviously that damage can vastly exceed the contribution of any individual patent. And so that's why, to the extent people can avoid it, you avoid even building anything in jurisdictions where making a huge capital investment in a jurisdiction where you're going to be subject to an injunction. You can't totally avoid it. There are lots of jurisdictions where you need to do business, and in the U.S., with ITC proceedings, I'm not quite sure where this is going to go, but the ITC is basically automatic exclusion order. I don't think there's been a case yet where they've issued an exclusion order for a FRAND committed patent, but you have that uncertainty in the U.S. as well.
Thanks, Joe. That was really helpful. I want to sort of dig into these. We've got different jurisdictions doing different things idea. And so, Rebecca, companies that operate globally, which you obviously have great experience with, they may face different approaches to SEP injunctions and FRAND enforcement across different jurisdictions. What happens when the threat of an injunction in one national market is used to influence global licensing terms?
Yeah. Well, in addition to Germany has been mentioned several times, and as you may have guessed from my funny accent, I'm actually based in Germany, and I know the environment a bit. And Germany is certainly one of the first examples that come to mind when you think about an injunction-centric jurisdiction, right? And my experience is that many judges in Germany, and probably also in other injunction-centric jurisdictions that have substantial experience in handling SEP disputes, generally tend to recognize that this injunction-focused approach is often unsatisfactory in the context of standard essential patents. They completely understand that the actual dispute between the parties is not about whether the implementer should stop using the patented technology, but about determining and finding, a way to see what an appropriate FRAND royalty for continued use would be. However, those judges at the same time find themselves bound by a legal framework that requires them to decide on the claim brought by the plaintiff. And if that claim is an injunction, the decision will be whether or not to grant an injunction. FRAND is then typically considered under an anti-competition defense brought by the implementer. And typically, the FRAND defense will require the court to consider whether the SEP holder has provided a FRAND offer to the defendant as a condition for potentially granting an injunction. An injunction would then only be granted if the implementer has shown that it's unwilling to accept that FRAND offer. Now, where the disputed standard is global and the players are both global, the offers that the SEP holder will make to the implementer will not be only about the one patent that is brought in front of the court. It's about a whole portfolio of patents. Those portfolios can be huge. They can include thousands, 10,000s of patents even, with a lot of uncertainty about how many of those are actually valid, how many of those are actually essential. And the offers are typically also made only on for a global license. And that means that those offers are also cover patents that are beyond the jurisdiction of that individual court. But at least where both parties, where the defendant operates globally, several non-US courts, certainly Germany, have accepted that a global-only offer is not necessarily inconsistent with FRAND. That is to say, you don't have to make an offer only for the German patents in order to have made a FRAND offer. And then they have proceeded to assess whether the terms of that global offer are FRAND. And this is meant to be pragmatic. And I think it also reflects a genuine desire to resolve the parties' overall dispute, because the parties' overall dispute is not about one single patent that is brought in front of that German court, but it's about the entirety of the portfolio. But it is problematic when a court effectively adjudicates patents outside its jurisdiction, whether by assessing their economic value or their likely validity and essentiality. It is even more problematic that some of these foreign courts focus much less on whether the offer made by the patent holder really is materially FRAND, but are ready to hand down injunctions based on perceived unwilling behavior of the defendant during negotiations. In these settings, injunctions may issue irrespective of whether the defendant was actually given the chance to accept a FRAND license. That's not merely a conceptual and theoretical problem, it's a very real problem, because when faced with an injunction in a foreign jurisdiction that represents a significant sales market for, say, an American manufacturer, that company will be under very high pressure to accept the global license offer adjudicated by the foreign jurisdiction, no matter whether a US court would have found the terms FRAND for the US part of the portfolio. And in essence, what the foreign court here does, and again, there's no evil will, but effectively it boils down to establishing the effect of an injunction on the American manufacturing operations of the company. And it effectively deprives the company of benefiting from the competitiveness of the US manufacturing policies. Very unsatisfactory, but difficult to solve as well. But we'll talk about that too, I guess. I hope.
Yeah. Well, thanks, Rebecca. That is helpful. That was a good explanation. Before we turn, we've got a couple of questions in the chat, but I have one more question for Charles, which is, these SEP disputes are often framed as private disagreements between patent holders and licensees. Why should policymakers also view them through the lens of competition, consumer welfare, supply chain resilience, and US leadership?
Yeah, so that's a really, really important question. So part of the answer is you can see how much discussion we've been having of different countries' approaches to FRAND litigation. And that's just indicative of the fact that when we're talking about these policy issues, we're talking about international global policy. And to the extent that the FTC or DOJ or the courts are rendering decisions on FRAND and standard essential patents, they are contributing to the sort of larger global conversation. That makes it fairly important in that respect. But the second answer is, as I talked about earlier, and as we've been talking about throughout this panel, all of these effects snowball. And so to the extent that there's even just a private disagreement over the meaning of FRAND or over the correct licensing rate on a certain patent, those decisions translate to manufacturing decisions, they translate into business decisions, they translate into decisions about how standards are developed, and that ultimately affects the competitive environment. To go back to kind of where Kent started this, the reason that we have standards is so that we can have lots and lots of different companies or different parties interacting within the same market, developing interoperable products, rather than having some sort of world in which every company is making things to their own standard and consumers have to pick one ecosystem or another and their stuff doesn't work together. The value of standardization is competition. It allows for companies to compete on a level playing ground and prevents consumers from having to deal with messes of incompatibilities. And to the extent that standards end up being harder to use because of these sorts of disputes, if these private disputes continue, it ultimately has that sort of larger effect on competition and on consumer welfare, and also on national security, which is something that I have written about in the past. One thing that policymakers have worried about in computer technology in the past is this idea that you might end up with single companies producing single types of equipment so frequently, and just like everybody using the same type of computer, that eventually, like, if somebody discovers that that computer is vulnerable to a virus, or that operating system or software is vulnerable to a virus, every single computer gets wiped out. This is what's known as the monoculture problem. It was sort of a big problem during the 90s, early 2000s. And an advantage of having a competitive environment in which there are standardized protocols, everything can talk with each other, but people implement those standards differently, is that you have a variety of systems out there. And that ends up being protected because it means that the United States infrastructure overall is less vulnerable to cyber attacks. This was an idea that I had, and then Michael Chertoff wrote about it. And Michael Chertoff obviously knows a thing or two about national security, so I think that this is a pretty good idea. But you can see at this point that what seems like just a negotiation between two parties over a patent actually has these very, very large ramifications. And that's why I think we're having this conversation, and why it's worth the attention of policymakers, because it does rise to these higher levels.
Thanks, Charles. That was a helpful explanation. One question that we have in the Q&A that I think any of you could answer, so I will let you all jump in. But how can balanced set policies support both intellectual property protection and the resilience of American manufacturing supply chains? Rebecca, it's all yours.
Manufacturing supply chains are in essence innovation ecosystems, right? Where each party in the chain contributes unique innovation to the making of an end product. Think of a phone. You have batteries that are, well, you innovate all of the time. You have displays, etc. So many different parties contribute different types of innovation. I think that the success of the American manufacturing and the resilience of the involved supply chain is predicated on each party having the opportunity to obtain a fair reward for the use of their innovation. If one party is overcompensated, this will come at the price of undercompensating other parties, and then you destabilize the whole innovation ecosystems and things fall apart. Now, when products incorporate patented technology that is owned by an entity outside the supply chain, that entity also contributes innovation, right? And intellectual property protection helps ensure that that patent holder can be fairly rewarded as well. SEPs, however, require special attention because market mechanisms alone cannot prevent that overcompensation of patent holders. Parties in the supply chain cannot simply walk away if the patent holder demands too much, because then they cannot implement the standard, and in many cases, the product will simply not be viable in the market anymore. And for that reason, you need targeted policies to protect the resilience of the overall innovation ecosystem when standards and SEPs are at play. Otherwise, it's very, very difficult to achieve that balance that you need for things to just work and the way we all would want them to.
Absolutely. I like the innovation ecosystem. That's a good way to talk about this. One other question we have in the chat, how can policymakers promote greater predictability in SEP licensing without prescribing a one-size-fits-all licensing model for every industry? I think we've talked several different industries have come up in the course of this conversation. So how do we make sure that we're not prescribing, like the question asked, one size fits all here?
I'll start just very briefly. We've basically all talked at one point or another about this idea that we need to separate out the value of the technology, the value of the underlying technology, from the value of standardization, right? Standardization of a technology, which then effectively compels companies to implement those technologies. Like, you can't sell a laptop without Wi-Fi at this point. Standardization confers value upon a technology that's unrelated to the technical merits, right? This was the $10 patent on Wi-Fi earning $1,000 example. And courts have recognized this. I think the best example of this is the Erickson versus Dealing case, which explicitly says that in determining the reasonable royalty rate under US patent law for a FRAND encumbered patent, you have to think about what is the value of the technology versus just what is the value that the technology gets because of the fact that it's standardized. And I think that that general principle can apply as appropriate in all sorts of different technical fields. And in the end, that is really where patent law as a general matter, but patent law particularly as applied to these standardized technologies, really ought to be going. It should be compensating for the value of technology, not the value of other things that just happen to happen to the patent holder. And to the extent that courts are really thinking through that and thinking through that in the context of all the remedies, including exclusion orders at the ITC or an injunction or any number of other things, I think we generally end up in the right place in a way that is adaptable to the necessities of each industry and each patent and each standard.
Charles,
Not to be.
oh,
Oh,
go ahead.
go ahead, Joe.
No, go ahead, Ken.
I'll just give you a really brief example why one policy can't fit all is because when you're dealing with things such as low-end telecommunication models used in smart meters, there's all sorts of smart meters, but your basic smart meter would love to use a module based on 2G. 2G is primarily no longer available in the world. There are some small pockets. The value of 2G patents is 0. So you're forced as the manufacturer to use the latest available standardized technology for which a rate above FRAND is being charged, because as you go through the discussion about what is the value of the technology and what is that technical value that's added, as Charles is talking about, you could use 2G, which has a 0 price tag, or you could use 5G, which has a different price tag. But when you're talking about FRAND, courts and other bodies do not consider the fact that you could use a former technology that for business reasons has been eliminated, that you and somehow take that impact into what is the value added by the newer technology to that product. Now, super smart meters that detect vibrations and all sorts of other things, that's different. They're not going to use the same technology. Same standardized technology cannot be used and actually dovetails into the newer standardization, such as 4G, 5G, and 2G probably couldn't handle it. So you can eliminate it in that example. Now that's one product, a module. It has 2 different applications, 2 different builds to a standard, but you should come up with 2 different price points, but you don't. You'll end up with whatever the price is that the patent holder or the patent pool is going to charge without any real meaningful background on what that technology added.
I just add that, as I noted earlier, the U.S. system was, of patent enforcement was set up long before anything like FRAND and standardization was an issue. The U.S. needs to think about, do we, people prefer the global license, both patent owners and often manufacturers as well. That's how they negotiate in the real world. And you basically can't do that in the U.S. We should think about a cause of action or some mechanism where you can get where you can adjudicate a global license in the United States. U.S. courts are frankly, in my view, more genuinely independent, fairer. You get more thorough discovery here. They could do a good job of setting rates. Also, a lot of this technology was invented in the U.S. If anyone has a right to adjudicate its value, it should be the U.S. And then you also need to think about some kind of mechanism to allow a broader set of adjudications rather than just piecemeal. And this is something that'll be resisted by patent owners. Everyone prefers to have their patent litigated in isolation and don't think about anything else out there. It's kind of the same thing with transparency. Like one thing they found, I think there was a case in the UK a couple of years ago where they pretty much found that one of the major cellular license holders was charging much higher rates to smaller entities because those entities lack the resources to litigate and discover the de facto rates being offered to others. So it's hard to there are economic interests that will resist this, but it just seems inevitable to me that we need a system that allows the U.S. to play the same kind of role that foreign countries are increasingly playing, and that allows an adjudication of an actual friend rate, and that takes into account that you're going to need to license multiple patents in order to be able to effectively use this technology as a manufacturer, and doesn't treat it as just a one-off, for individual patents. And these problems are just going to keep getting worse and worse. None of this is going to get solved on its own, and at some point we'll need some kind of a statutory fix to just change the system and take into account some kind of efficient, rational way of setting rates in these cases.
So what I'm hearing is it's super easy, and certainly we can figure it out with a quick fix.
Yeah, right.
Well, I think we don't have any more questions, and I think that is a good place for us to leave it off. I want to thank all of our panelists for joining us today. And I will just do a quick plug. If you enjoyed this conversation, Save Our Standards is hosting a full day of them in September. It's the Standards Leadership Forum. It's a new event that we're putting on. It not a full day, 12 to 5 on September 23rd, but we hope that you'll join us. It's a free event to attend. And so we look forward to continuing these important conversations in September. So thank you all.